All right. Welcome to Ask Two Lawyers from sunny San Diego today, Keith.
Yeah, how you doing, Stuart?
Good. Your microphone wasn't working. What's going on there?
Well, I don't know. I was trying to sing into it earlier, and I probably broke it. But we got it fixed. We figured it out.
Yeah, sorry, we're a few minutes late, but we are on now. And Keith, I'm really excited about today.
It's gonna be good.
We have a very special guest with us today. I reached out to her thinking that, she'd say, well, give me a call some other time, when I can work out some time but she did work out some time to spend with us today. And we have former Judge Elizabeth Scher. She's known as Judge Liz. She's currently a partner at Conrad and Scher Trial Lawyers with offices in Fort Lauderdale, Florida, and Brevard, North Carolina. I think I said that right. Sorry for the folks of Brevard if I did not. And then I think it's Quito, Ecuador. So they have an international flair going on with this firm. Yeah, pretty cool. And you can find Judge Liz on YouTube and TikTok at The Judge Liz. It's at The Judge Liz. And Instagram, it's a little different. It's at j.elizabethscher. And you can find her law firm at conrad.scher.
And all those descriptions are in the link below.
They are, yeah. So you can just go and check the YouTube channel out. That's actually how I came across Judge Liz after I had watched the trial from a few years ago, the Parkland shooter trial. That's where I first became familiar with her, but then I've also been watching her coverage of the lively Baldoni stuff. It's no surprise to anybody watching that Judge Liz presided over one of the most closely watched criminal trials in recent American history. She served as the presiding judge in the trial of the Parkland school shooter, and that's a case that gripped the nation. We all watched it for a long time. I think it was 6 months of coverage. That shooting occurred in February of 2018 at the Marjorie Stoneman Douglas High School in Parkland, Florida. The shooter that day killed 17 people, 14 students and 3 staff members, and wounded 17 others. And the attack only lasted 6 minutes.
Just horrible.
The victims range from ages 14 to 49 years old. It remains one of the deadliest school shootings in U.S. history. The jury recommended a life sentence, but they failed to reach a unanimous decision on the death penalty. I think Florida has since changed the law on that. We can ask Judge Liz about that. I think I don't think you need a unanimous jury anymore for the death penalty. And on November 2nd, 2022, Judge Liz sentenced that shooter to 34 consecutive life terms, 17 for the murders and 17 for the attempted murders and of those wounded. Judge Liz is a very impressive personality. I can't wait to introduce her to everybody. Listen to some of these things about her. I'm sure she'll be embarrassed that I'm going to read all of them, but I must. She retired from the bench in June 2023 after serving more than 10 years as a circuit court judge in Florida. Before serving as a judge, she served as an assistant state attorney from 2001 to 2012. During her time as an assistant state attorney, she handled cases involving violent habitual offenders, and she was a first chair on more than 75 jury trials. Keith,
that's impressive.
That's really impressive. Jury trials, I mean, if we say we have 10 jury trials, we're feeling pretty good about that. 75 jury trials. And they were not for tickets. They weren't for people driving.
No, these were real
tickets.
cases.
There was murder, arson, carjacking, robbery, and home invasion. Throughout her career as both a practitioner and a judge, she's handled over 100 jury trials. And of course, the Parkland shooter trial was one of those. She was death qualified by the Florida Supreme Court, making her eligible to preside over death penalty cases. And she's also presided over numerous murder cases and capital offenses. We've invited Judge Liz here today to give us her thoughts on juries, judges, lawyers, and of course, the lively Baldoni case, and quite frankly, anything else she wants to talk about.
Absolutely.
So without further ado, let me welcome in Judge Liz.
Hi there.
Hey, thanks for joining us. We're so glad to have you.
Thank you so much for having me. And that was a very, very flattering description that you gave of me. I appreciate it. I am blushing a little bit, but the way you guys said it just was so nice. You made my day.
Well, let me be fair. We have our audience, which we call the jury pool. And I actually cut out about 2/3 of what I know about you. So you really are an impressive person. And we would love to talk to you just a little bit about your background, if that's okay.
Absolutely.
All right. So my first question is, you were a practitioner for 10 years or so, and then you became a judge. And I'm a practitioner, and I rarely get a judge's ear. We do bend ears during mediation, or if we're in trial, every once in a while we'll ask judges for tips. But from a view from the bench, how did it change for you when you went from a lawyer to a judge? How did you see it differently after becoming a judge?
Well, I can tell you that it changed over time. So at first, I get appointed to the bench, and I'm now getting behind the scenes with these people that I've always held, judges. Like if you see a judge off the bench, in passing and they're not wearing your robe, you're sort of like, hi, you almost want to salute. And usually the person looks like way taller than they do on the bench, or a lot shorter, or just a lot different. And it's almost like a kind of a shocking thing. I remember as a lawyer, I ran into a judge at a store. I forget the name of the store. And I was like so nervous. So then I get appointed, and now they're all taking me back into their chambers and they're talking to me. And I'm realizing that, okay, these are just people. And not only that, but a lot of them are pretty quirky and maybe not as regal as you sort of anticipate. And so I was 35 when I was appointed. Our governor at the time, Rick Scott, was he's very forward thinking as far as who he was going to appoint. It used to be before Governor Scott that they wouldn't even consider anybody with less than, like, let's say 15, 20 years of experience as a practicing lawyer. So when I started putting in other words, applying for the position, I had 10 years of experience. So that was sort of a new thing, but Governor Scott was known to appoint judges. I have a good friend named Rudy Ruiz, who was appointed after only 5 years as a lawyer. He's now on the federal bench, and he's one of the smartest individuals I've ever met. I always tell people, this guy's probably going to be president of the United States one day. That's how great he is. But I think it speaks to Governor Scott's plan in that he wanted to build a legacy. In his mind, age a number of years doesn't necessarily have anything to do with ability or intelligence or how well you're going to do. But that being said, so I get appointed, I'm 35 years old. I like to dress up and play Barbie, sort of, I wear makeup, I like to dress. And so I have all these older men that are sort of like, they don't know what to make of me. I remember I go to judge school the first time we call it the judicial college. And I don't know if they call it the dean or the head of the judicial college. He's probably in his, I don't know, maybe 60s, late 60s, gray hair, exactly what you would think of if you think of a judge. Most people think of an older white gray hair man. So he sort of was, I don't know, he didn't know what to make of me. And he finally one day he came up to me and he goes, "You kind of remind me of like Katy Perry." And I said, "What?" Katy Perry was like the only person that he could think of. Guess he couldn't think of anything else to say. And I thought, I really don't know how to take that. But people didn't know how to take me. But then very soon after that, Governor Scott started appointing many people that were even younger than I was. So the bench sort of in Florida became a different composition. And so I was no longer like this stark, much younger person that stood out like a sore thumb. But it was different. It was one of the other things that was a big difference is, you can't. Sometimes I'd want to get down off the bench and tell the person, "Move over and let me do this. Let me show you how you need to do this." And it was like, I'd have to bite my tongue. So that part took a lot of getting used to. I would actually have to just sort of look down and like doodle just to not want to pull my hair out, because sometimes lawyers, and I'm not talking about young lawyers. I had a lot of young lawyers assigned to my division. Those lawyers I loved. As long as they would be prepared and try their hardest, I was willing to work with them. But I'm talking about older lawyers who are more seasoned, who are supposed to have so much experience, and they come in and they don't know what the heck they're doing. They don't know how to properly cross-examine a witness. That makes you want to pull your hair out. And of course, you have to remain stoic and not show any emotion and not roll your eyes and not make a facial expression, which is very hard for me. If you've ever met me, anyone who knows me knows that that was one of the hardest things for me.
Yeah. It reminds me of a time when we were in trial and there was a younger lawyer on the other side, and the judge was trying to help them out. And it's one of those things where the lawyer objected and said, "At relevance," and the judge is like, "Not relevance." It's kind of like, let me give you a little
Hearsay?
Yeah, hearsay. Yeah. I turned to Stuart and I'm like, I don't think this is supposed to be multiple choice.
No, it's more like this: objection, relevance, sustained, hearsay. That's how you sort of like, rather than make it that obvious, but
Yeah.
or overruled on those grounds,
Yeah.
And I would never
Right.
do that during a trial, but during a hearing, sometimes
Yeah.
you get when I was in criminal, you get the same public defenders and state attorneys that are assigned to your division for usually a period of a year or so. And so they almost become like your kids a little bit. And and my lawyers knew that I was like a mama bear. Like, if you get some private lawyer that comes in and tries to be unkind or unsportsmanlike conduct sort of thing to one of my younger lawyers and bully them, oh man, that was a big mistake in my division. I didn't put up with that. I would quickly put them in their place.
Yeah. And that reminds me of a question that I did have for you. And in terms of when you're seeing attorneys argue, whether it's in the pleadings or certainly during oral argument, and let me put this in the context of Lively versus Baldoni, but it's a more general question. So as I'm seeing the pleading in Lively versus Baldoni, it tends to be, and I'm going to generalize here, but it tends to be that most of the motion pleading we've been seeing on the Baldoni side, it's been very professional. It's been, kind of by the book. They argue the facts, they argue the law. But we've seen some motions on the Lively side, in particular, the motion to dismiss by Ryan Reynolds, where it's very bombastic. There's a lot of snarky comments. There's a lot of kind of personal attacks and things like that. So as a judge, when you're hearing these arguments from attorneys, do you prefer when the arguments are kind of by the book, just tell me the law and facts and let me decide, versus these like kind of snarky comments that go back and forth? What was your view of those things?
I think it's entirely inappropriate and unprofessional. And I'll tell you this, to me, being professional and courteous to both, the other side and to the court is not the number one priority. You may not be the most, talented lawyer around, but if you are polite and you are professional and you do your best to make your arguments, to me, you're going to get a lot more than somebody who comes in and is cocky. And I got to tell you, reading the pleadings, even from both sides in this case, especially in federal court, I mean, federal court is just a totally different ballgame. And I'm sure you both know this. It's like that it doesn't fly. In federal court, the judges are appointed for a lifetime. So they don't have to worry about somebody running against them. If they, get on somebody too hard, they very rarely get appealed, or much less than state court judges, again, because the litigants don't want to appeal them because they know they have a lifetime appointment. And the next time they go in front of them, it's not going to be good for them. So, in federal court, not so long ago, was that women were required to wear skirts. I think that was just 15 years ago. Right. That's how formal it is. So I am quite shocked that the lawyers are behaving that way. And also, I will tell you from a judge's perspective, it is very, okay, let me see how I can put this. Most times, the personality of the lawyer is very similar to the personality of the litigant. In that, if the lawyer is obnoxious, most times the litigant is equally obnoxious. If the lawyer is professional and courteous, do you see what I'm saying? Because
yes.
What I find that happens is you get a lawyer that's a total jerk, right? And they come in and their client is not like that. They see how they behave and you can see the look on their face, like, what is happening here? But judges, we often say amongst ourselves that usually if the lawyer is acting like that, you don't take it out on the client, but you usually, there's some type of, something that brings those two together. But no, I don't think it's appropriate. I don't like it. Now, let me say this. There's a few lawyers in town that are extremely professional, extremely prepared. I'll give a name, for example, Jeremy Kroll. He's a criminal defense attorney. He's wonderful. Wonderful. He's so well-spoken. His mannerisms, he's polite, he's professional. I have seen him get upset with the state attorney one time, the prosecution. And that person I knew deserved it. So if somebody like that, who's usually almost always the epitome of the professional standards, and they get snarky and mad, then I know, you know what, the other side had it coming and they get a pass for that. But in general, if somebody comes off, swinging like that, it means it's going to be an ugly process and an ugly trial. And that's kind of a judge's worst nightmare, because you're no longer calling balls and strikes. You're ending up having to be some type of, parent and scolding both sides and using your different tools to try to keep everybody, acting the way they're supposed to be.
Well, Judge Liz, I really appreciate that, because I've been telling Keith for a long time he's got to get the snark out of all of his filings and oral arguments. So,
I'm not that snarky.
So hopefully that will help him out a little bit. But I do want to shift the attention just quickly to juries, and then we want to get to judges after that. But juries in general, you've got a lot of experience with juries as a practitioner and as a judge. And I know as a judge, managing that jury is tough. I mean, we lawyers are always taking breaks, and you judges are sitting there going, "Hey guys, you're killing the jury," because they're running back and forth, and you're wanting things to be done quickly. These people want to get back to their families and friends and jobs and whatever else they have going on. But people in our jury pool have asked multiple times, tell us about the juries. I mean, do jurors really take their job seriously once they're impaneled? Do they care? Do they want to get the right decision? Do they follow the judge's instructions on the law? Can you just give us your gut on, how do you feel about juries after seeing it on both sides?
Okay, so absolutely 99% of the time, I believe jurors really do work hard. They want to get it right. They want to deliberate. They appreciate the process, because you can see it. You can see it in their faces, and you can see it in their questions. I'll tell you from my perspective as a lawyer and as a judge, the type of jury that to me is never a good sign is the jury that's coming in, from the breaks, and they're all laughing and they're talking and they're almost getting along too well, which you would think would be a good thing. But in my opinion, that's the type of jury that's there for social hour, and they're not the ones that always seem very serious. And you think, oh, are these people like against me, or what are they mad at? No, those are the ones that are taking their job seriously and really, really wanting to follow the law and do it right.
Okay, and do you want to follow up on judges?
Yeah. So how do most jurors view the judge? What's the demeanor in terms of how they view the judge? Because I would imagine that there's a lot of respect that juries have for a judge, but I'm just curious what your experience had been there.
I think most of the time, so let me tell you this. So when I'm a lawyer, I wasn't thinking about the jury and the jury's time at all. I'm thinking about trying my case, putting my case together. And as a prosecutor, let me say this. I just finished a civil trial with my law firm, and there was 10 lawyers on each side, plus paralegals, plus IT people. When you're trying a case for the prosecution, you may have 150 exhibits in a murder case with DNA evidence, fingerprint evidence, video evidence, surveillance, with all these witnesses. And guess what? At least in my jurisdiction, you're trying that by yourself. That's all on you. You're coordinating all the witnesses. You're taking care of all the evidence. So the last thing on your mind is if I have to make the jurors wait for an extra 10 minutes. And I remember thinking, why do the judges get so insane about this? I'm doing the best I can. I'm trying to manage 100 different things, and I've got a lot on the line. Because when you've got as a prosecutor, when you've got a victim who's had a family member murdered or has been set on fire by their husband, that's the last case I tried. The lady was literally lit on fire by her husband and melted and almost died. When you've got something like that on the line, that's a lot of pressure, because the last thing you want is that person to be able to get out and, hurt somebody else if you make a mistake. As a judge, then I realized, I get it now, because it makes us crazy, because what we do is we get a rapport with the jurors, right? So the jurors, I want the jury to trust me. I want the jury to respect me, and I want the jury to respect the process. So when I keep them waiting in the back, because the lawyers told me, they'll be ready at let's say 9 o'clock, and 9 o'clock comes and the lawyers come, and sure enough, they have 15 motions they want to present, and they didn't tell me about this. And I've got usually in Florida, most cases have 6 jurors. Capital cases, we have 12 jurors, but we usually have several alternates. And I know these people have important things. They've got families, they've got jobs, and nothing would make me crazier than having those jurors wait. And sometimes you have to make them wait for hours. And then what happens is the judges blame it on themselves, even though most of the time it's not the judge's fault. It's not necessarily the lawyer's fault either, because sometimes things come up that you don't anticipate, but the judge sort of takes the fall for it. And the jurors appreciate that. And I would always tell them, look, I'm so sorry. Please don't hold this against the lawyers. There are things that come up. I was the one that took the time, et cetera, et cetera. So I think that jurors really respect, if you do your job right, I think the jurors really respect the judge. And if they respect the judge, they respect the process, and therefore they take their job very seriously.
Okay, well, that's fantastic. With that foundation in mind, we've talked about judges and juries and your experience. And so now let's turn to the lively Baldoni matter. And I'm just curious, from 40,000 feet, why are you interested in this case, and why have you been commenting on YouTube?
Well, I'm interested because the world is interested, and I'm building my channel, and I'd like to talk about the cases that people are most interested in, and they can't get enough of this case. And it's funny because, before this case started, my daughter was very, very like a Blake Lively fan. She loved her. And she would say, Mom, we have to watch this movie because Blake Lively's in it. And I'd be like, who the heck is Blake Lively? So I knew a little bit about who she was. Justin Baldoni, I knew because I watched Jane the Virgin on Netflix, but it was almost like a pity watch kind of thing because I couldn't find anything else to watch. And, it was okay, but nothing fantastic. It wasn't like one of my, best shows I've ever seen. So I knew who he was by his face from that movie. But, these are two relatively, to me, unknown actors. Now, of course, Ryan Reynolds was always, I love him. The movie that he plays with Sandra Bullock, I can't think of the name of it, where she's his boss and she's from Canada and she makes him marry him so that she can stay in the country. I can't think of the name of the movie, but he's hilarious.
I can't help you, unfortunately, but I'm sure we'll get a comment here from the jury pool that'll help us
Yeah.
out.
The proposal.
I thought
the
he was-
proposal.
The proposal,
Okay.
yes.
The Proposal is like one of my all-time favorite movies. He's fantastic in that movie. So funny. And then he was in, okay, so I'm not gonna be able to remember all the movies, but I'm not into his more sci-fi movies that he does now, but
Right.
I've always known who he is. I didn't realize what a fantastic businessman he is, that with all of his sort of extracurricular business ventures. But as far as Blake Lively and Justin Baldoni, I don't know. I didn't know very much about it, but everybody's so interested in it. And now I'm interested in it,
Yeah, it's captivating. And as
It
you get
is.
more and more into the pleadings, and, it's interesting too, because we were talking to another attorney yesterday, Ron Zambrano, and he made a good point that typically when you see a complaint, they're very bare bones. They have just barely any facts in them. They're very dry. And here we have complaints that are, 600 paragraphs. And Baldoni had his Exhibit A with all the text messages. I mean, it's just so rich with kind of evidence up front, which you don't normally see in a case, is this much evidence up front. Was there, as you've been looking through this, what has been some of the evidence, I guess we'll start for the Wayfair parties, let's start there, that you found kind of most convincing or interesting or helpful? Anything in particular that kind of stands out to you?
Oh, absolutely. In fact, I have a video that's coming out tomorrow on how I would present the case if I were the lawyers for Baldoni. And I'll tell you this, they have like 5 smoking guns, in my opinion. They have the Forbes interview that was uncovered, where Blake Lively is essentially giving her MO, how we would say in criminal, of what she does, where she basically comes in as a coy, actress. I'm going to get my job and I'm going to be an actress, but I'm in the meanwhile going to be trying to get writing credits and executive producer credits. And I'm going to be, chiming in on my wardrobe and blah, 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 blah. And this whole thing is fascinating to me also because when I retired from the bench, I had a contract with Fox to have my own judge show. So I got behind the scenes look at a lot of how this works and how many producers there are and writers there are and how many different components go into it. Unfortunately, the show was canceled when Fox had to pay out that huge, almost $1 billion settlement for the statements that their news department made about the voting scandal. And they cut like almost their entire Fox television, what was it called? Fox Television Productions. I think that was one of the facets of Fox, one of the subsidiaries. And they downsized that dramatically and cut my show, which was heartbreaking because it was going to be really, really, really fun. And of course, they treated me like royalty for the first couple of months and flew me out to, this is sort of a side note, but they flew me out to LA on this plane where I had my own suite and I had a stylist and a makeup artist and a hair. I mean, it was just like, it was almost like pinch myself. This is too good to be true. I should have known it wasn't going to go through, but it was fun while it lasted. But anyway, so I have some experience with this whole, writer versus producer versus, cameraman versus, all the different people, because I actually did a shoot once where there was probably 40 different people involved, looking at the camera, telling me, do this, do that, taping my wardrobe or fixing my hair. So, and I looked down one time and somebody was actually like bronzing my ankles. Which I thought, I'm a horseback rider, so when I'm not at work, I'm always in boots and long pants. So my legs are like freakishly white, but that's how much detail goes into all of this. So when I see and hear her saying, "Oh, I'm trying to take over this, I'm trying to take over that," I can imagine in my head how they have purposely all different people that are in charge of those jobs. So for her to think. And I think it's important for people to understand that it's not normal for an actor or an actress to have all of these responsibilities. Maybe they're given some type of producer credit because that they negotiated that in their contract, but a lot of times that's in name only. But as far as doing rewrites and taking control of the wardrobe and really just trying to take over the whole production, that is, in my understanding, is that is not typical. That is not normal. And in that Forbes video, she says that, this is what I do. I think that's the worst piece of evidence against her, best for Baldoni. The second one is where the dance scene that in her complaint says that there was no sound. Well, yes, there most certainly was sound. How did she not know that or figure that out before she filed that pleading? I don't know. But her saying that he was, improvising and doing inappropriate things when she's at least 50% culpable, if not more, because she was doing exactly what he was doing. So I think that's extremely damaging to her case. And then more recently, I saw a video where she actually is on the red carpet and she tells E! News that Ryan Reynolds wrote the rooftop scene. And she just flat out says it. And when you consider the fact, and then also the text messages about how Ryan Reynolds and and Taylor Swift are her, I think she calls them like her soccer moms or her den mothers, basically like mother bears that are protect her at all costs, knowing that those two people are like superstars as far as fame and fortune and public following. And that's an imbalance of power to me. That's bullying. That's like, me, I don't know, saying, just so happens I'm friends with Pam Bondi, so now she's the attorney general. It's like me saying, well, Pam thinks blah, 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 if I'm trying to argue a case, which I would absolutely never do because it would be entirely inappropriate. But just because you know somebody with a lot of fame and a lot of power doesn't mean, those two had absolutely nothing to do with it. And I think that will be shown at trial. And I think those are some very big points, good points for the Baldoni team.
What about Ryan Reynolds being involved in this? I mean, obviously there's some evidence, and it has to be proven still, that he went to some high executive somewhere and basically publicized and stated that Justin Baldoni was an S predator. And I've looked at the case law on this. There's not too many worse things you can say about another human being, because that if that sticks, that ruins your reputation forever. And you're not welcome in anybody's home. You're not welcome around your neighbors. I mean, it would be just brutal to go through. To me, I feel like that is a huge piece of evidence that should be used in this case. And I really think they should direct a lot of their attention to Ryan Reynolds, because that's such a simple thing for a jury to grasp. If that is in fact what was said, did he say it? And if that's what he said, I think a jury's going to look at that in a very disfavorable way to Ryan Reynolds. What are your thoughts on that?
100%. I'm so glad you brought this up, because when I saw that, first of all, an sex predator is defined in any state as worse than a sex offender. In other words, there's sex offender databases where people have to be registered, and an sex predator is even higher than that. They have to have done something that is so egregious and criminal, like a forcible rape on an underage child. At least in Florida, that designation makes you where you can be subjected to you all, I'm sure, have different laws, but basically where you can be committed for the rest of your life, even when your criminal sentence is over. So that's like calling somebody a mass murderer or worse to me. That's like the worst type of criminal you can be, the highest type of criminal. And I 100% agree that is, you can't say, well, and I know he says, well, I believe it to be true. So that's, that's a defense. That's, you when you look, all they would have to do, if I were the Baldoni team, I would look up the definition and give examples, and I would show that. And there's no way that he thought that was true,
right?
Because he would have to be a rapist, a violent rapist of the highest form, and that's more than hyperbole. That's just outright wrong.
Yeah, that's what I thought was so ridiculous about Ryan Reynolds' argument on that front, is because he tried to argue, well, that's just an opinion. And when I say that, nobody could assume that I'm insinuating a factual misstatement. Oh, I think you can. I think when you call somebody a word like that or a statement like that, I think you're insinuating they're a criminal. And like you said, it's one of the worst forms of criminal conduct in that area. And so to say that, well, I'm allowed to express my opinion. Well, you could have said, I hate him. You could have said, you could have even said, I think the guy's a monster. That'd be very different from saying he's an S predator. Saying he's a monster is more of an opinion, I think. But S predator, I mean, that's crazy.
And then they doubled down. Not only did they say, well, if it's not an opinion, then it's a fact. And if it's a fact, then we have an ultimate defense to it. I mean, that was just over the top in my mind. And, I thought the case had a chance of settling. I think it probably still will settle at some point. But man, when you have that kind of lawyering going on, I find it, in my mind, in my opinion, is irresponsible.
Yeah, absolutely. Or maybe they don't have any. No, but because you guys practice civil, right? And you know how bad it is. So it's not just like, it's not, because I'm thinking, well, maybe they just do civil and they don't understand the criminal side of it. As from the criminal side of it, I get you're calling him a violent rapist, and that is not okay. You're calling him something that, like, just from being a criminal judge, is like the worst, the type of case I don't want to ever have to preside over. And yeah, it goes beyond irresponsible. It's unspeakable. Yeah, that's how we viewed it too. And yeah, we don't know the criminal side. We don't do criminal law, but I think just knowing what we know about the law, it certainly is terrible. I want to talk to you about this mystery subpoena. So we have spent a lot of time on our podcast mapping out all of these dates when everything was filed. The CRD complaints filed December 20th. Lively files her lawsuit in New York federal court December 31st. Lively actually filed something in Texas, a 202 petition to try and get pre-litigation discovery, but that's not filed until January 2025. There's no pending lawsuit that we know of that predates the CRD complaint on December 20th. And yet the New York Times publishes December 21st and says that they reviewed thousands of documents that were obtained through a subpoena. Now it appears from various news reports that maybe there was some lawsuit filed in New York, some mystery lawsuit, and somebody, possibly at Manat,
issued a subpoena on that lawsuit to Stephanie Jones in order to get that phone and get those text messages. And it just seems so crazy to me that somebody would do that. I mean, when you had somebody, I mean, I want to have your thoughts on that, Judge Liz, but also just as a judge, I mean, when you see somebody coming into your courtroom and they're doing things that, to your view, appears to be trying to play games, trying to work outside of the given process under the Code of Civil Procedure, how do you handle that? Or how did you handle that as a judge?
I find it, first of all, let's assume there was some mystery case filed that none of us know about, okay? By the time that case gets a case number, it gets assigned to a judge, the judge has the, time to hear the case. I find, and then there's going to be the others, who's the other side of that, right? Yeah. And by the time they get to and there's got to be some type of discovery supporting a subpoena, getting somebody's phone. So they're not going to be able to get that straight away. And you would think any supporting factual information that would help them explain to a judge why we need to issue the subpoena would be known by the wayfarer parties. I mean, to me, it just doesn't seem like it seems like it's made up.
Yeah.
Because by the time all of those things happened, wayfarer would have known, because the proof that would have had to be provided to the judge in order to subpoena somebody's phone, physical phone. And that's actually, a lot of providers don't keep the text messages, right? And they're hard to get from a law enforcement standpoint. So a lot of times law enforcement will actually, and this, by the way, wasn't involving law enforcement, but I'm just saying, even involving law enforcement, sometimes they can't get the actual text messages with a subpoena because they're not kept, depending on the provider. So they have to get a search warrant for the actual phone and hope the text messages were saved on the phone. In fact, there's many providers that do not keep the text messages regularly. So just it's very unbelievable to me that there's any way that there would be some lawsuit, again, that would be able to meet the burden to get a subpoena issued by a judge, and that all, that would happen in a very short period of time, that Wayfair and their parties would have no idea about it. I don't believe it. I don't believe it.
And the thing that hits me on this subpoena thing is that when we try cases, and I'm assuming this is true on the criminal side too, there's a sense of fairness that's built into the procedures, and that both sides should get notice, both sides should be able to review the evidence. There's not Perry Mason moments anymore at trial, because everybody knows what's happening. That's why on the civil side, most cases settle. And in fact, I think this case will probably settle too. I do want to turn just briefly towards California law. And I know you're a Florida attorney and you were a Florida judge, but there's these three privileges that Blake Lively's attorneys have pointed out. And I think they did a very effective job of pointing them out. And the jury pool, there's some people in the jury pool that do not like me bringing up 47.1. And the reason they don't like bringing it up is because they say I bring it up too much. But here's the issue with 47.1. It's basically an anti-SLAPP statute. I think that's essentially what it boils down to. And if you accused me of SH and I was your employer, and you sued me for SH, or you even just gave information to somebody else, you communicated that information that I had SH'd you during the time you worked for me, and I get angry when I find out about that, and then I turn around and I sue you for defamation. And let's say I have a lot of resources and you don't. I just basically sue you into oblivion, and you ultimately have to settle the case. And then I'm going to put you through depositions. I'm going to put you through discovery. I'm going to make life as miserable as I can on you. Well, 47.1 comes along. It's effective January 1 of 2024, a relatively new law here in California. And it says, hey, if this communication was made and it was reasonably made, and somebody's not lying, there's not actual malice, which is a high standard, actual malice is, then you can't, Justin Baldoni here in this case, cannot turn around and sue her for defamation. Now, he can sue her for defamation, but if he does, what he's setting himself up for is a damages phase if she becomes the prevailing party. And to become the prevailing party, that's a whole analysis there. But let's just assume somehow, some way, there's a 20% chance that Blake Lively could become a prevailing party, 1 in 5. She would get not only all of her attorney's fees, but now under the statute, which is very draconian in my opinion, she would have treble damages, and she would have punitive damages available to her. Have you looked at this law, and is there anything similar in Florida? And what are your thoughts about all of this?
Okay, so people don't like when I say this, but I live in Florida, and I think and I'm going to tell you what I think. I think Florida laws are so much better than California laws. I think you guys have some of the goofiest laws that I read and I say, what? Like you have a law in criminal that says something like self-defense. It's like a self-defense +2. And I can't even remember, but I was reading about it and like, what the heck is this thing? So I understand Gavin Newsom, he was behind this whole 47.1. But the thing is, you got to look at both sides here, okay? Because women can be equally as evil as men, right? And no, do I think a woman should be able to be sexually harassed in the workplace? Absolutely not. But to make the burden of proof higher for somebody who wants to essentially defend themselves in court. And I mean, Justin Baldoni, he's fired from WME based on the word of Blake Lively and Ryan Reynolds within 2 days. That's a huge deal. People may not realize that. You get fired from WME, that's the biggest talent agency probably in America. And the other ones aren't going to want to touch you now because now you've almost been blackballed. So to say that now you have to expose yourself to huge liability, treble damages, punitive damages, and your burden of proof is higher just because this person's made a complaint against you, it seems entirely unfair. And let me just say this. If you look at the criminal side, the burden of proof is higher against the person who's accused of wrongdoing. In other words, the state's burden of proof is beyond a reasonable doubt to prove the charges against. Now we're switching sides because in this case, Justin Baldoni is the accused, okay? I know it's not the same. It's not a criminal case. He's not facing prison, but he's facing basically his livelihood. And you're making the burden of proof on him higher than on the person that's making the accusations. I think in civil, it should be 51%, keep it the way it is. I don't like the law. I think it's unfair. I think it's going to be unfairly used. Do I like or agree with the fact that some men will take advantage of a woman who perhaps doesn't have the money and can't fight back? No, that's not fair either. But our system of justice, I mean, it's a democracy, and this law is, I think it's unfair. I think it's unconstitutional. I think somebody should challenge it.
Yeah. And I think the problem that we've stated with 47.1 is the treble damages and punitive damages. I think that's where it goes way too far. It's one thing if you had a attorney's fees provision. Okay, fine. Prevailing party gets their attorney's fees. But this law,
but it's only a one-way street.
Exactly. It's a one-way street. It's not the prevailing party. And so it only goes one way. And then it adds this nonsense about treble damages and punitive damages. I mean, it really is crazy how far it goes. And I think that there's going to be at some point, if it's not this case, at some point, there's going to be a constitutional review on that. Because it's one thing, we do a lot of financial elder abuse cases where when somebody's found liable of financial elder abuse, they also can be liable for treble damages. But that makes sense because they did something bad and they've been found liable doing something bad. Here, the treble damages are for the mere fact of filing a lawsuit.
Right.
Yeah. I think I like I said, it doesn't surprise me because I think and I'm sorry to say this, you two seem like very nice gentlemen. And I'm sure you practice law very well. But I think that your state has a lot of goofy laws that that other states do not. And I'm sure people don't like Florida because we're very, probably on the opposite side of the spectrum. But, we don't know. We don't have anything like that.
Well, I had a professor in law school that said California never had a thought it didn't codify. And so that, we have a lot of laws and we certainly don't agree with all of them. But this one in particular is really pointing out how it can be abused, which is, unfortunate.
Yeah, absolutely.
Can I put you in a difficult position?
Sure.
And let's say that Blake Lively and Ryan Reynolds called you up and they come and meet you in your beautiful law firm there in Fort Lauderdale. And, they say, hey, Judge Liz, I know you think that Justin Baldoni's the good guy here and, we're the bad people, but we just fired all of our lawyers. We want to hire you. And I'm not saying you take them on, but what advice would you give them on how to move forward in this case? Is there a path to redemption legally? Is there a path to redemption in the court of public opinion? How would you tell these people to fix this problem they've gotten themselves into?
I mean, honestly, I don't know how there's a way to walk this back. I mean, you'd have to have, my first thought is mediation, but you'd have to have like the best mediator in the world to be able to show you all know mediators, the good ones usually go to both sides. And for people that don't know that, at least in Florida, this is how we do it. One party's in one room, the other party's in another room. They're not all at the same table. And the mediator basically goes back and forth and gives you all the weakest points of your case and sort of almost tries to break you down so that you understand that you are not 100% right, not even close, and does the same to the other side until they can get the parties to agree on something. I don't know. I don't see that happening here. The problem is you can't walk this back. What are you going to do? Is there any way? I mean, I guess you could start with seeing if seeing if Ryan Reynolds can get Baldoni back with WME, have them make a statement that this was a misunderstanding. The things that have been said from the Lively party about Baldoni, I don't know that he can recover from that. And yes, I do understand that. I believe in the court of public opinion. He's winning. People are more on his side than the other side. But that's not going to be the problem. The problem is going to be that no one's going to want to work with him in the future because they're going to say, oh, no, because what if other people jump on the Blake Lively bandwagon? Or what if what she says is true? Because if you read her complaint, there are some things that are not refuted by the Baldoni team as far as, men making jokes about their, multiple partners and pornography and all these kind of things that the Baldoni camp has not refuted. So some of the things could be true. We won't know until we get to trial. But then again, you look at some of the things she says, and she's like the queen of the whole, what Donald Trump refers to as locker room talk. She's the one that initiates the locker room talk a lot of the times, according to the text. She's got a mouth on her like a male football player.
Yes, a sailor, yeah.
But and so it's hard to imagine a woman who's comfortable talking about, a ball buster and not tennis balls, but, all these things are suppositories and blah, 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 sexual references and what you would expect, theoretically for men to be saying. It's hard to imagine that she could be offended by other things, but I don't know. It's hard to believe. Then if you read her, what she says happened during the birthing scene, you're like, geez, that's terrible. But then this actor, Adam, I can't remember his name, who played the OBGYN, gave a statement just recently saying that that's not what happened. So you're like, okay, well, there's 100 people in there. They're filming. There's producers, there's co-producers, there's cameramen. Like there's going to be a lot of people that are going to be able to say one way or the other whether or not this happened. So, I don't know. I think this case has to go to trial. I know you all think it's going to settle. I don't see how this settles. I feel like both sides have dug in way too deep, made it way too personal, and there's a lot at stake. I don't see Blake Lively. If she doesn't prevail in court, I don't see her ever getting another movie job again, ever. Maybe I'm wrong, but if I'm funding a movie, I'm not going to want her anywhere near my set.
Right.
Because according to Baldoni, she creates havoc. She's like the talent diva, the worst nightmare, the stereotypical, actress who makes all these demands and makes everybody's life miserable. And she's not the talent of, let's say, or not as popular as, let's say, a Jennifer Lopez or Jennifer Aniston or a Julia Roberts, who may have a similar reputation, but they're worth it because they're going to bring hundreds of millions of dollars to every movie that they star in. She's not of that level. So I just don't see anybody wanting to hire her. And on the other hand, what's Baldoni going to do? He's got no agent. I mean, I think people are going to be scared of him too. So I'm going to tell him, let's just prepare for trial, I think.
Yeah, it's a tough situation. I mean, I've said that if I represented Blake Lively, I would advise her to do everything she can to get out of the case before her deposition's taken, because I think she's going to it's not going to be pretty. Her deposition is not going to be pretty. Now, unless they have some evidence that we don't know about that they're keeping under wraps, that's just going to blow it wide open. But like you said, there's so many people that are on the set during these different situations that are going to come in and testify. And I think Lively knows what they're going to say. And if you know that they're not going to be favorable, you better be finding some way to get out of this case, and you better do it before your deposition's taken, because it's not going to be pretty.
But then you have to wonder. And like I gave the example of when I did the photo shoot with Fox, and there was like 40 people in the room, like literally touching my ankles and my hair and everything. So this is a movie set. So there's going to be more than that. So why in the world, if you've got 1,000 witnesses who are there every minute of every day for every scene, it's not like her and Baldoni were ever alone. I mean, except for the, times that they're having meetings, but why would you file this?
Right.
Which makes me think, well, they've got to have something that everybody doesn't know. And I try to tell my subscribers, look, I try to end every video with a caveat saying, look, nobody knows until the case goes to trial. The evidence is evaluated by the judge. What's probative, what's not, what comes in, we don't know for sure. Yes, it looks very good for the Baldoni team based on the videos and things that have been made available. But, if he's some kind of closet perv and saying stuff to her and doing things that we don't know about, and she's got witnesses to it, the whole case is sort of mind-boggling.
Yeah, it really is. Well, we have, I know, quite a few people with questions. I hope if you have a little bit more time, Judge Liz, we'd love to. Okay, let's producer Eric, do you have some questions for us?
Yeah, absolutely. So this one was from Lindsay Ann Parker. She's wondering, what does it take for a constitutional law to be taken into a formal review? I know you guys, keep mentioning this, maybe being a possibility. Does it take cases like this for 47.1 to be reviewed or rewritten?
Well, somebody would have to file a lawsuit alleging that it's unconstitutional. It would have to make its way through the California courts and into the federal courts, and ultimately the could go all the way to the U.S. Supreme Court. So it would just take somebody. Now the party would have to be have standing. So in other words, somebody like me couldn't just bring the lawsuit because I've not been affected by 47.1. But yes, it could take somebody like Baldoni who's being affected by 47.1, who would have standing to challenge the constitutionality of the law. And by the way, that's a question that's better for these two experts than for me, because we're talking about. I just sort of wing that.
No, you said it exactly the way we would set it.
Okay, good.
That was perfect. Yeah.
It checks out.
Yeah.
Thank you, guys. Okay, next up, Dima. I would like to know the repercussions for falsely filed subpoenas.
I'm not sure if this person, Dima, can expand on what she means by falsely filed subpoenas.
Let me take a crack at it. So, Judge, if I'm in front of you, let's put you back on the bench, and I open up a lawsuit somewhere else in the state that has nothing to do with the lawsuit that we're currently in front of you or planning on being in front of you about. And I issue a subpoena without giving anyone notice of the subpoena for somebody's entire cell phone with their text messages, their emails, their financial information. I mean, just everything on it. I'm the only one who gets it. Then I run off to the newspaper and I give the newspaper all this information, and I've disclosed this to nobody. And then one day I'm standing in front of you and you know that I've done this. What are you going to do to me as a lawyer for doing this type of behavior?
Okay, so you're saying that basically you went and got another judge to allow you to issue an ex parte subpoena. Ex parte, by the way, guys, means without the other side present. Is that what you mean? I could have been clear. Here in California, we don't have to have a judge issue subpoena, so you may have to do that in Florida. So we could just issue them ourselves here
as lawyers.
But we have to have a case, and we have to give notice to the other side. That's the key point that's missing in what I was doing. I just went and got somebody's cell phone, gave them a subpoena, a sham subpoena, to some degree, because it hasn't been served on everybody, That's at least what the allegations are here. And I think that's what the question was, is what's the punishment to a lawyer or to a law firm for that type of behavior?
So you're telling me that in California, a lawyer, not a prosecutor, but a civil lawyer can issue a subpoena without the judge ratifying it?
We're very powerful out here, Judge Liz. We could, but there's rules, and of course, we have to go and answer to a judge if we don't follow those rules.
Okay, and I need to know more because I'm completely unfamiliar with this. In Florida, you have the judge, the only person that has subpoena power is the state attorney or the prosecution's office, or a civil lawyer has to move the court to issue a subpoena. So the judge has to consider it and then sign off on it. So it's really the judge that's issuing the subpoena. So what are the parameters? Like, do you have to have a certain amount of proof, or what are the, I have to know more before I answer, because I'm completely unfamiliar with this type of situation.
In California, lawyers can issue subpoenas, but it has to be in the context of a litigated case. So once I have a case filed, I can issue a subpoena. We have certain hold times. Once we file a case, we have to wait 20 days. The subpoena has to be relevant to the case that I'm litigating, and I have to give notice to all the other parties. And so I think what we're getting at here is that somebody played a game, possibly, but let's just assume that this happened. Let's assume that somebody filed a kind of a bogus lawsuit, and then they used that case number to issue a subpoena, which a lawyer can do, but they didn't give any notice to anybody. Now they're coming into this known case of Lively versus Baldoni, and they're saying, oh, I want to use all this evidence that I got using this, bogus subpoena over here. And as a lawyer, I can issue a subpoena. But we all know that subpoena, under this scenario, under this hypothetical, was issued for the sole purpose of trying to do an end run around giving people notice.
Okay.
And so now that I'm in this litigated case, now you're the judge in Lively v. Baldoni, and I'm like, hey, I want to use this evidence that I got through this other subpoena. What would your reaction be to that? And then also, if I, as a lawyer, brought a motion to disqualify the attorneys who did this, as a judge, how would you view a motion to disqualify on that?
Okay, let me just say this. When I answered about this subpoena issue before, I didn't realize that the laws in other states allowed this to be done without a judge being involved. So everybody who listened to me talk about that before, keep in mind that I was assuming a judge was involved in this also. That's why I said I don't believe it happened. Okay, so in this case, I'm going to consider it exactly as I would in a criminal case. The evidence was obtained illegally. It's not coming in, and you're going to have to meet a new threshold and with following all the rules. If you want to actually get this form of evidence, I'm going to report this lawyer to the local bar and let the bar handle it. And I'm also going to, if there's a motion to disqualify the attorney, there's different rules in different states, but I think that's very likely that that's going to happen. I would not be happy about this. This evidence would not be coming in. No one's going to backdoor and not follow the rules, not in my courtroom, not ever.
Yeah,
civil or criminal.
The Daily Mail has reported that apparently a lawyer at Manat, which Manat is a well-respected, large firm, multinational firm, they're reporting, so we don't know if this is true, but they're reporting that somebody filled out a subpoena on kind of a dummy case that nobody knew about, and they used that subpoena to give to Stephanie Jones, and then Stephanie Jones gave up the entire phone from Jennifer Abel, and that's how we end up getting all of these text messages and emails and everything well before the CRD complaint was filed, well before any legal action was filed.
Okay.
And so and it's interesting because Manat is the lawyers that are doing, in my opinion, they're doing a very good job with the 12B6 filings. I think that the Baldoni and Wayfair teams will get past the 12B6 phase against Lively and Reynolds, even if they have to do a second amended complaint. I think they'll get past that. But
Sure.
But it's funny because Manat is the law firm that did this, and so if I'm Brian Friedman, I'm gonna make a big deal about this with the court. I'm gonna file a motion to recuse Manat, who's already put millions and millions of dollars and time into this case. Yes, there'll be other lawyers that can take over, but what a hiccup the other side would have to go through if somehow, some way you were able to get the law firm recused. Now, keep in mind, maybe everything was above board here. We don't have enough reporting. The Daily Mail has not given us a copy. They won't publish the subpoena which is just, it's kind of like, why aren't you guys, if you have a subpoena that shows that this is the subpoena that was used to get the records here from Jennifer Abel's phone via Stephanie Jones, why can't we take a look at that subpoena? Because we'd like to see what case it's attached to. We'd like to see what lawyer sent it. And we also want to know who was it sent to, who got notice that this was very private information. I mean, a cell phone, I remember in law school when I was there, it used to be back in the 50s, you'd walk into some business and you might get a file drawer open and you take a few files out, right? But with a cell phone, you're talking about, I don't know about you, Judge Liz. I wouldn't want people to see my cell phone, okay? I've got all kinds of stuff on there that's crazy,
Well, and as the person who is sort of the recipient of the subpoena, does this person have any right to object? Because in Florida, even an agency that has subpoena power, let's say the prosecutor's office, and you're trying to get somebody's records, you have to provide them with reasonable notice, and then they have an opportunity to object. So to me, another reason why I think Florida law is another, pat on the back for Florida law. We don't do it this way. And I think this is an example of why we don't do it this way. A judge has to sign off on it because, God, think about, lawyers. You guys know there's a lot of pretty scary lawyers out there that do things that are like, what? But I mean, you hope that they don't. And when you graduate law school, you're under the impression that we all abide by the rules of professional conduct, but then you soon learn that we don't, unfortunately. But in my opinion, if that Daily Mail is not going to tell you any information about the subpoena, it's probably likely because all they have to do is give you the case number and then you can give the information, right? So if they won't give it over, it's probably because it wasn't done in the legal course of things and it's, problematic.
Yeah, and parties do in California, parties who receive a subpoena do have an opportunity to object to it. And so then it raises the question of why didn't Stephanie Jones object to it? Why wasn't there notice given to the Wayfair parties? Because certainly had they known about this, they would have objected to it. And we saw the contract between Wayfair and Jones Work. There's 3 pages of confidentiality in there. There's all sorts of confidential obligations. Right. And so if I'm Jones Work and I know that I have an agreement that includes confidentiality, I think I'd be a little nervous about complying with the subpoena without contacting Wayfair and say, hey guys, are you aware of the subpoena? Do you know this is going on? So,
unless they included language in the subpoena, you see it often like disclosure of I can't remember the exact language, but on the bottom of a subpoena or a court order, it usually says that the party receiving this cannot disclose this to anybody under law or penalties of perjury or whatever it is. I don't know if you all do that in your state, but in Florida, we do that so that, especially in a criminal investigation, so that people can't disclose what they're being asked to turn over.
Yeah.
So I'm not sure if they included something like that and made the Jones, her name is Jones?
Jones Work. Yeah. Stephanie Jones at Jones Work.
She maybe thought she wasn't legally allowed to disclose the request. I don't know.
It seems like Stephanie Jones, again, we'd like to see a copy of the subpoena, and I'd like to know what due diligence did her lawyers do, her legal team. Did they, because it sounds like they got a document that said subpoena on it, and it sounds like they said, oh, here's the phone, and they just gave it up. But we'll have to see what happens with that. We're not sure what's going to happen. And by the way, if Baldoni's team, the Wayfair parties, had received a copy of the subpoena, they most certainly would have filed a motion to quash.
Oh, for sure.
And so, Judge, you talked about fruit of the poisonous tree, I think. You didn't say those words, but I remember in law school, that's illegally obtained evidence in a criminal matter. And I think that the same analysis could be used here. I'm not sure about evidentiary sanctions because I think that this stuff can still be obtained. But the problem is, what is all the stuff that was obtained? And there's all kinds of private things on a phone. And so was all of that given to the New York Times or whatever paper looked at this, or is it just a few select, 1,000 texts that were given? And, phones hold so much data these days. Sure. It's just crazy to think about. It reminds me of that Alex Jones trial. Was it Alex Jones where he didn't object to his phone being turned over and there's apparently a waiver in that state, right? And so the prosecutions there, they were able to use his phone and everything that was in it. And
so much information.
So much information.
Yeah. Well, he's not the smartest guy.
That's true.
You don't even want to know what I think of him, but
no, we do.
Oh God. I think if I really told you, your video would get those flags from YouTube that says like I forget those flags that you get when they say like you said inappropriate content.
Yeah.
I mean, what a jerk. I think you
It
can
is-
say jerk.
It is interesting though, because I mean, we practicing in California, we, as their attorneys, we issue subpoenas. I didn't know that in Florida you couldn't do that. Now it raises the question in my mind, in what state did they even file this so-called lawsuit,
Right.
and what are the rules there? Because obviously different states are different as to how subpoenas are issued.
Right.
And I had no idea that Florida operated that way. I assume that, you know, you
Well, if you
issued
think
subpoenas the
about
same
it,
as we do.
there's privacy concerns.
Yeah.
Because even, and the reason that I gave the sort of fruit of the poisonous tree without saying the words is like, okay, would you have been entitled to this information if you had done it the legal way?
Right,
And I think the answer would most likely be no.
Yeah.
Or the judge would have to review it under seal, which for those of you who don't know means the judge gets something in their chambers. It's like all sealed up. The judge reviews all of the information, just the judge without the parties. I've had to do this many times. I go through it and then I determine what should be disclosed and what shouldn't be disclosed. And then I give it to my assistant. We're very careful. Whatever I decide can be disclosed is discoverable. We make sure to only give those portions. The rest is sent back to whoever I got the information from. And then the lawyers are only given what I say, with a written order explaining my decision. At the very least, you would think that would have been done.
Yeah, it seems like those are some nice protections that are built in Florida. So, but until then, we have, I don't know how many lawyers we have, 300,000 lawyers in California running around issuing subpoenas.
Yeah.
And we just have to follow the rules if we're going to not get in trouble with the judge. But, we have had you for a little over an hour, and you've been very gracious with your time. I do want to point out one more time that people can find Judge Liz on Instagram at j.elizabethsharer. And we've got that linked in our description below. And also on YouTube and TikTok at the Judge Liz. And the Judge Liz, I understand, and you've already given us a little flavor of this. I think you have a video premiering tomorrow on YouTube, and you talked about some of the evidence you were looking at, but can you give us another nutshell of what that video is going to be about?
So I'm sure you guys try to do the same thing, but everybody's covering Justin Baldoni, Blake Lively case, everybody and their mother. And so what I do is I spend my nights, I don't sleep very much, but I try to watch a lot of other people's content, and then I try to come up with an angle that maybe somebody else hasn't come up with so that I can, just offer a different point of view. So in my video tomorrow, what I've come up with is I've gone through all of the evidence and all of the pleadings ad nauseum. And I thought, you know what? I'm going to sort of present the case as if I were the attorney for Justin Baldoni, not the full case, because I think that would take days, but the most damning evidence against Blake Lively, what witness I would call, and how I would present that evidence to refute her allegations and or support Justin Baldoni's case. And I sort of present it in that way. Now, I don't have actors playing, the witnesses, and I'm not really acting as the lawyer, although I do give some cross-examination questions that I would ask and how I would ask them, just to try to give people an understanding of how I would try the case if I were representing Justin Baldoni. And I do plan on, and this may not be as popular, but I do plan on, if I can, coming up with the same type of thing if I were to be representing Blake Lively. Now, we know that her allegations are mostly allegations, and there's not a lot of proof that's been provided to the public as far as video and text messages and things of that nature. But I am going to try to do it from her side too, so that, I'm not just one-sided. I think it's only fair. So that's going to be tomorrow. Hopefully it'll be interesting for people to watch and to see. It's funny because I've noticed a lot of people who very clearly follow this case, very, closely follow this case. But I did a video recently, I called it like Justin's Smoking Gun, and I showed her interview from Forbes. And the video went, well, for my videos, because I'm very new at this, I just started really consistently producing content like in February, March. People went crazy. Maybe I had one comment saying, this came out a long time ago. Well, you know what? The 30,000 other people were thrilled with this. They hadn't seen it, and they were telling me things like, you should send this to Baldoni's lawyers. And I'm thinking, you know what? I'm sure they've already seen it. But I think sometimes that those little clips of evidence, when there's video and things, people really appreciate that, because maybe they've read about it, but it didn't like sink in until they actually see it. So it should be interesting. I hope so. If not, we'll try again for something else.
I think it's going to be a great video. It sounds very interesting, and you bring a unique perspective on it, being a judge and a prosecutor, and you have so much to add to the discussion. And I wish that we could help you out and play some parts. I don't have the abs to play Baldoni, but I wonder if maybe I could play the Sorowitz part. I feel like I could play a pretty convincing billionaire.
Okay.
I don't know.
All right.
Oh, that's a good idea. So, but I have to say this. I love that you have me on your channel. I'm so thrilled, and I was very flattered. And the fact that you let me get into some of my background, I really, really appreciate that, because I'm known sometimes as like I hate to say this, the Barbie judge, the cute judge, but no one ever lets me give my background. And I have a lot of it, and I tried a lot of cases. And the fact that now these people, that your subscribers have heard that, it really, I feel, gives me more credibility, because I don't know, I don't go on my own channel and give my credentials. Maybe I should, I don't know. But the way that you all were appreciative of my background and complimentary of my background, it made my day. And I really, really appreciate it. Because I like people to know I'm not just the judge that was appointed at 35 that likes to dress up and play Barbie. There's more to me than the makeup.
Well, Judge Liz, I mean, I have a couple comments on that. First is I got to know you back in 2018. You obviously didn't know me, and watching the Parkland case, you definitely have substance, and you did a very good job in that case, in my opinion. I also, as we were getting ready, Keith, I went to Keith's office earlier yesterday and today as we got your bio, and of course we did a deep dive on you as well. And I said, gosh, I was really looking forward to talking to Judge Liz, and I was not nervous at all. But now I'm getting nervous because have you seen this person? And I do mean it. You are an incredibly impressive person. You're a life experience. You're so young. You still look 35. You don't have to tell us your age now. But your experience is unbelievable. And if anybody wants to take some time just to do some internet searches on what you've done and what you're currently doing now, you're a civil litigator. You're bringing all of this ability that an experience that you've had over the years into the civil courtroom now. It's just such a pleasure to have you on. This conversation was so much fun. And maybe we can have you back. Maybe we can come on your show if we could benefit you in any way. But it means so much that you were on, and I don't know if you wanted to share anything as well, Keith.
Yeah, no, we're just truly honored to have you on, Judge Liz. And for people who aren't attorneys, they don't understand that 100 jury trials is a big deal. I mean, that is a really amazing accomplishment in and of itself, and that doesn't take into account all your other many accomplishments. But yeah, very much a pleasure that you would agree to join us, and we really enjoyed the conversation.
I had a great time. The time flew by. I will say that to anybody who's interested, tonight I'm going to be on News Nation at 8 p.m. Eastern Standard Time, talking about the Florida State University, which is I'm an alumni of Florida State University. Tragically, there was a shooting where I understand, I've been pretty busy today, but the last count that I've heard is that 5 people were killed. And I have to say that enough is enough. I'm so angry, and it's like the families from the Parkland shooting. If you can imagine, every time one of these shootings happens, it just opens up the old wounds for them. They can't heal because there's a new one. And now you're going to see the other side of me. I get mad. There's it's just not right. And Florida, we passed the Risk Protection Act right after, within 2 weeks of the Parkland shooting, which says that anytime somebody displays behavior that could be a danger to themselves or others, and they're known to have firearms, a judge can take those firearms away. And so I was just thinking last week, we haven't had any shootings in Florida since that law was enacted. And there's actually a lot of statistics on the law and how great it is. And whenever I see a shooting in another state, I always think, why don't they just, it's not rocket science. Call one of our legislatures, get the law, pass it, and then you guys can do the same thing. And it's a bipartisan law because both sides of the aisle support it. And it's like, it's just, you know, you don't have to battle the NRA and you don't have to, you know, you have to take sides on the Second Amendment. It's just a no-brainer. If people have mental health issues and they've got guns, you take them away and you revisit it every, you know, 6 to 12 months. So the fact that we've had one in Florida, and again, I've been busy preparing for this podcast and doing other things at work, so I haven't had a chance to really look into it, but it's disheartening. We need to figure out a way to do better. We meaning the citizens of the United States of America, like we need to do better. I don't know the answer, but there's got to be something. And unfortunately, I am going to be going on News Nation to talk about this, and also CBS tomorrow morning. I'm the go-to when a shooting happens. And to be honest with you, sometimes I say no, because for me, it makes me want to just, you know, say all of the bleep, bleep, bleep. It's maddening, but we have to bring attention to it. We cannot forget. We need to know about these things because our lawmakers need to pass laws, need to work together. Because we've got to stop this. It doesn't happen in other areas, and it shouldn't happen in the United States of America, which I tell people I believe to be the greatest country in the world, and we've got to figure it out. So with that, tune in News Nation at 8 p.m. if anyone's interested. I'm not exactly sure what I'm going to be talking about, but you know, since the Parkland shooting, where for a very brief time the death penalty could only be imposed if it was a unanimous verdict, we had one juror that was a holdout. Actually, she refused to deliberate, and that's a whole nother video. But after that, the Florida legislature codified the Florida Supreme Court case that came out before the Parkland shooting, but just hadn't been before the Parkland shooting trial, but just hadn't been reviewed. The legislature had not gotten to it, but the Florida Supreme Court had said, listen, it doesn't have to be unanimous. But that had not been codified, I think, within like a week after the Parkland shooting verdict came out. Now it's just a majority, and then ultimately the judge decides that'll be the difference for this individual, if he's even been apprehended, which I have not had time to check. I have to look into all that. But my prayers go out to those families, because this is something that is so painful, and it's something that nobody should ever have to go through. And my heart goes out to those people and any people who have been victims of this type of thing, because it's the type of thing where I have a daughter, and you just think, God, by the grace of God, go I, because you just never know when it's going to happen. But
yeah, it's just horrible. Well, I'm glad that you're a resource, at least for that. And I'm sure it's not easy for you to talk about, but our hearts and prayers go out to all of the victims and families. And we hate to hear about these things. And, we agree. I mean, hopefully there's a solution out there where we can do better, and we will, we have to do better.
We do.
But thank you so much for sharing that. I know that's not easy for you to talk about these things, Judge Liz, based on what you've been through. But obviously you're a resilient person, and, you're fighting for the greater good. So it's wonderful to hear you say that. Thank
you so much. You guys are so genuine and so graceful. I think we've got to meet one day. Maybe Fox will decide they have enough money to produce my show and send me out there.
That'd be great.
Wait, but which one of us is more genuine?
I think you're both wonderful. I really enjoy you guys, because I got to tell you, I tell people all the time, lawyers drive me crazy in general. And I feel like I can say that because I am a lawyer, but lawyers can be obnoxious. But you guys are great. You really are.
Thank you.
And I'd love to have you on my show. I don't know how to do all that stuff yet because we're new.
By the way, your office staff was outstanding to work with. They were great guys. I can't think of their names right now, but wonderful.
Spencer and Calvin.
Yes. Yeah.
Thank God for them. They teach me. I mean, I know I'm learning, but I don't know all of the ins and outs of it. But we're building a new studio. I don't know if that's what you call it. It looks like a little bit of a dungeon right now. It's all, just brick, not brick, but like the CBS block. And it's a small room, but we're going to make it, because it's really hard to do all the stuff in my office that I work in. So we're doing that. And then hopefully we'll be more equipped to do these types of collaborations. And then I'd love to collaborate with you guys again. You were wonderful. And by the way, your subscribers or your fans, I don't know how you would call it, but I knew exactly who you are when you reached out to me, because I try to read all of the comments on my channel if I can. And many of them have asked me, have you ever watched your podcast? Ask Two Lawyers. I'm sure it's Ask Two. It's not on the screen right now. Ask Two Lawyers. And have recommended your show to me. And it was shortly thereafter that you all approached me. So I was very, very flattered. So thank you so much for having me. And let's stay in touch.
Absolutely.
Awesome. Yeah, that's our jury pool out doing the work. So thank you so much.
Okay. You all have a great night and a good weekend. And it was lovely to meet you. And thank you to your subscribers for watching. And I hope we'll talk soon.
All right, Judge Liz, take care for now.
Thank you.
We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.